to file item 58. 58, members, by Senator Schiff. Clerk will read.
Senate Bill 144 by Senator Schiff and others, and act relating to the State Bar.
Mr. Hertzberg.
Thank you kindly, Mr. Speaker, and for accommodating our needs to immediately transmit this to the Senate if it...
Mr. Hertzberg, one moment.
Yeah.
Members, the House will be in order. The House will be in order.
Thank you, sir. If we're able to pass this measure, Mr. Speaker, people tend to think that this bill is only about lawyers, and in fact, I was going to start my remarks with a lawyer joke, but ladies and gentlemen, I couldn't think of one. On a more serious note, not only is this bill about fundamentally restructuring the State Bar, it's about who we seek to protect, the consumers of California. In every district we represent in this state, in every one of our 58 counties, there are hundreds and hundreds of complaints, totaling to 10,000 complaints a year that are made, or inquiries that are made at the State Bar with respect to attorneys and questions about attorneys. And for the last year and a half, those questions have gone unanswered. The system, when you call, all you do is get the other end of the phone, you get a recording that says, sorry, we're out of money. And we're out of money because in 1997 there was a dispute with the former governor, and we had a political stalemate over what the bar should or shouldn't be. And what we have done in this measure is come up with a common sense set of reforms that reform and come up with a new State Bar and deal with many, many of the issues to which were the subject matter of those disputes. I will highlight just a few. First, with respect to contracting, any contract over $50,000, Mr. Speaker, can I get the attention of the membership?
Members, the House will be in order. Mr.
Everybody's got to vote on
Hertzberg.
it. Thank you very much, Mr. Speaker. Requiring with respect to contracting that all matters over $50,000 require the approval of the Board of Governors. 2, reduction of dues to all lawyers by 20%, and a provision that if lawyers who earn less money at the lower amounts have a reduced amount of fees. 3, that attorneys take the appropriate number of hours of continuing education as all other professionals are required to do. And most important to me, that the IALTA program, the program which funds 113 agencies in the state of California for people to have low-income access...
Mr. Hertzberg, one moment.
Thank you.
Members, the House will be in order. Hold on 1 minute, Mr. Hertzberg.
Certainly.
Members, the House will be in order. The noise level has gotten entirely out of control today. We need to get this back under control so we can have a free flow of debate on the floor. Members can hear the debate. Thank you. Mr. Hertzberg.
Thank you, sir. To preserve the $11.6 million that funds these 113 agencies, Mr. Speaker, to ensure that wrongful evictions for families that don't have the money get their day in court, to ensure that single mothers who are denied assistance will have advocates to cut through red tape. Example after example where these types of services will be available to people in all of the counties throughout California. We have now developed, by this measure, a permanent solution to this problem so that the bar doors can be opened, so that the people who were terminated can be hired back, and so we can have a intelligent, reformed State Bar. I ask for your support with respect to this measure. And before one thing I want to say on a personal note, as a point of personal privilege, so I want to specifically acknowledge, in addition to the bar president we have today, Mr. Marshall, Mr. Marc Adelman, who was a sole practitioner in San Diego. And this man came to Sacramento 36 times on his own money. He came here and fought and came to meeting after meeting after meeting during a year when we were in stalemate, and he put his heart and his soul and his money into representing the State Bar in an effort to try to reach a compromise with this with respect to the bar last year. Unfortunately, in the wee hours of the morning on the last day of session over a $10 bill, we weren't able to reach a compromise, but I just wanted to personally acknowledge him and for what he did with respect to this measure. And also, Mr. Nissen, I ask for your support of this measure.
Mr. Ackerman.
Mr. Speaker and members, I rise in opposition to this bill. And while Mr. Hertzberg won't give a joke, I'll try one. I was concerned about the three strikes rule when that went through, because most of us that are lawyers, we had 1 strike being a lawyer, 2 strikes being a politician. That 3rd strike might get to us. Not a good joke. I also want to commend Mr. Hertzberg for the work he did last year on this bill. In fact, many of us were prepared to support the bill that he had completed last year. Unfortunately, that was not able to go forward, and we're looking at the bill that we have before us today. This bill has many problems, including allowing the bar to continue to lobby, and it's confronted with two court cases, one on the IOLTA, which is currently being reviewed by different court cases to determine whether or not that's legal. One of the things that the bill does is to reduce the minimum legal education from 36 hours to 25 hours. So we're sending the message to the people of California that we think lawyers need less education instead of more, which I think is the incorrect message. And a very important thing that came out this week in the Sacramento Superior Court was a ruling on a court case that was filed a number of years ago, which basically said that a lot of the matters that the bar was doing that we felt were improper, and one of those is connection and sponsorship of the Conference of Delegates. The State Bar still continues to have a relationship with the Conference of Delegates under this bill, and we think that is improper. Also, it said that the State Bar could not do outreach programs, it could not do lobbying in Washington, D.C., and probably more importantly, it cannot lobby 31 of 40 bills that it did in the last couple of sessions which had no germaneness to duties of the bar. I had the conversation this morning with one of the lawyers involved in this case, and Mr. Hertzberg will tell you that this case has nothing to do with this current bill. And right now, the best I can tell you is no one knows. I spoke with one of the attorneys this morning who felt that it probably did have some impact on this current bill, but it was really too early to tell since they just had the decision and they haven't completely reviewed this bill. I would urge the members on both sides of the aisle in looking at the bar bill that we need to get the bar back to basics. The basics that the State Bar should be involved with are admissions, discipline, and educational standards. This bill goes way beyond that, and I think we need to get it back to where it should be, and I urge your no vote on this bill. Thank you.
Mr. Cardoza.
Thank you, Mr. Speaker. Very briefly, I have a question of the author. I'd like to preface it with a statement that Mr. Hertzberg, I've watched you work this bill for 2.5 years now with Mr. Schiff, and you deserve great praise.
Thank you, sir.
You also, I agree with many of the statements you made today, but my question is, sir, the one point I didn't hear was whether or not this bill had any effect on the total number of lawyers that would be in the bar.
Yeah, it probably does. Probably a fewer.
Well, that would be a good thing. Thank you very much, sir.
Thank you, Mr. Cardoza.
Ms. Kuehl.
Thank you. Mr. Speaker and members, I rise in support of this bill, but most particularly to add some information with all respect, correct a statement made by Mr. Ackerman about a recent case that was issued this week. Just in case any of you are really interested in whether a case says that what we're doing in a bill is okay or not okay, before you vote on it, I just wanted to indicate that this case, if you hear about it, Broster House, actually would have no impact at all on this bill, and I'll tell you very briefly why. First of all, Broster House is a decision of the Superior Court which has no binding authority on any other courts at all, not even another court down the block. And it's a tentative decision because all of the issues have not even been heard in the case. Consequently, it's a bifurcated trial, and we haven't had the decision on all the other issues. But let's assume that it was a higher court, and let's assume that it was a final judgment. Still, there would be no conflict between Broster House and this bill. Broster House says the Conference of Delegates may not be funded with mandatory fees. Now, I think it should be, but I lost that argument. This bill says it can't be funded with mandatory fees, and therefore it totally comports with Broster House. Broster House says that any legislative activities of the bar sections may not be funded with mandatory fees. Now, I definitely think they should be, but I lost that argument. So this bill does not allow mandatory fees to be used to fund the state bar sections, and therefore it totally comports with Broster House. I could show you the rest of this 3-page memo showing you every way in which the bill, though I don't like all the cuts that were made in the bill, as it now stands, does comport with that case, and therefore, just if you were interested, there is no conflict between this bill as it's now drafted and that current court case. I think that this did strike a balance, as Mr. Hertzberg indicated, and I somewhat reluctantly, though fervently, encourage your aye vote.
Mr. Baugh.
Thank you, Mr. Speaker. Ms. Kuehl, I would like to get that document. I haven't had the opportunity to read it, but I would like to pose the question to Mr. Hertzberg. Is there anything in that decision that is inconsistent. Can you first of all explain the decision and whether there's anything inconsistent in this bill today with that opinion? And I also understand there is a second phase that's going to determine the quantity or the amount of money that was improperly assessed. Could you address that issue? And also finally tell me if the judge in that case drops the dollar level down a lot lower than is reflected in this bill, do we have a conflict that needs to be resolved by the courts?
Yeah. Well, let me tell you, Judge Englund, when he decided this case a few days ago, basically was looking at a law that was written in 1989. That was then, this is now. This is a 1999 bill that's very different than the law in 1989. He only looked at the law during 1989. But if we look at the provisions of the law that he looked at in 1989 and we compare them to the proposal that you have before here today in Senator Schiff's bill, SB 144, you will see line by line we have addressed those. The issue of voluntary participation in lobbying has been addressed. The issue of paying for sections has been addressed. The issue of paying for the conference of delegates, all been addressed consistent with the decision. In our brief analysis, we've met this morning on this. We've gone through it line by line. I think I might have the same memo that Assemblymember Kuehl has. We've looked at that, and it tells us that what we have done is we have met, we have anticipated, and that this is a reasonable compromise that really deals with the fundamental issues that have fueled this debate for the last number of years in reaching the conclusions in SB 144. So not only, as Ms. Kuehl articulates, this is not binding law on anybody except for the litigants in the case. And as we all know, and you in particular, Mr. Baugh, as a lawyer, know that so often it's the Superior Court cases. I want to proudly stand there and say you're a lawyer. Know that in these Superior Court cases, often it is the appellate and the Supreme Court cases that make the law. So our analysis is there is nothing that's inconsistent. This only addresses the 1989 law, and in fact, I like the fact that we had this case because it really does make the fine point that we have addressed those issues in SB 144.
Ms. Jackson.
Thank you, Mr. Speaker. I know a few lawyer jokes, actually, Mr. Hertzberg. I'll share them with you later. And I appreciate Mr. Cardoza's frolic into the world of fewer lawyers, and perhaps that would be a good thing until you need them. But lawyers, like any other profession, are necessary to our society. And lawyers, like any other profession, are comprised of good and decent people and some people who don't necessarily fit that category. For some reason, we have taken good fun and poked at the profession, the legal profession, for many years. And there is some good reason for that, as there is for just about every profession. But this bill, I think, addresses key issues to both protect the public and also that protect the integrity of the profession. It requires continuing education. This is a very good thing in any profession. It addresses discipline. This is a very good thing for the consumers and to protect the public and, frankly, to protect the integrity of the profession. It also deals with the fact that lawyers are, generally speaking, fairly active in their communities and care about public policy and want to participate in public policy, and sometimes are foolish enough to even want to serve the people of the state in the Assembly and Senate. And so I think this bill takes a very good compromise at what has been a heated debate, and I want to commend Assemblymember Hertzberg and Senator Schiff for tackling a very, very difficult situation. But this bill addresses, in the best interests of the public and the best interests of the profession, efforts to keep it going and to protect all of us who wish to serve and who stand proudly to say that we are indeed members of the Bar of the State of California, and those individuals who need the guidance of the profession as well as the protection of the profession as they pursue their lives. This is a good, fair bill. It is a compromise bill, and one that I think deserves your aye vote. Thank you.
For the debate or discussion, seeing and hearing none, Mr. Hertzberg, you may close.
Thank you, Mr. Speaker. Very briefly, just to address a couple of points that Mr. Ackerman made. The component of lobbying is only a checkoff. It's voluntary. We've addressed that issue. Also, the response to Mr. Baugh's question is addressed. The IALTA issue involving the lawyer trust accounts has been remanded to a Texas court case, and it's still pending, and whatever the federal court says, it says. And the issue about reduction of hours has to do with whether or not lawyers are required to have law office management as part of their continuing education. So these are really, in my judgment, peripheral issues in terms of the core issue of this measure. There has been an extraordinary amount of energy and attention that has been put into this bill. It fundamentally protects consumers. It fundamentally reestablishes a system of process and procedure that deals with the discipline of lawyers and the fair administration of justice of the legal system as it deals with lawyers. In every other profession, whether it's architects or engineers, there are boards that regulate those bodies to protect the public. I stand here today, and I couldn't think of a lawyer joke because I'm proud to be a lawyer. I've been a lawyer since I've been 2 years old, I think. And, you know, I've had a lot of cases, and I haven't earned a lot of money and fought for justice and feel that that is a good value to society. And I stand tall and stand proud with other lawyers and ask for your support of this measure. Mr. Pappen.
All debate having ceased, the clerk will open the roll. All members vote who desire to vote. 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 The clerk will close the roll and tally the vote. Ayes 43, noes 31. The measure passes. Mr. Hertzberg, for what purpose do you seek recognition?
Request immediate transmittal to the Senate, sir. Thank you.
Without objection, such will be the order. Mr. Thompson, for what purpose do you seek recognition?
Mr. Speaker, an inquiry of the chair. What is our schedule today, those of us that have business down in the district? Do you have any idea of that at this point?
I do, Mr. Thompson. The intent of the presiding officer is, at the direction of the Speaker, we will work the file rather extensively today in order to get the file as small as possible, because, as you know, it will continue to build during the remaining 3+ weeks that we have here during the first year of the 2-year session. So what we will do today is work for several more hours to try to get the file dispensed with and made as small as possible for when we return next week.
In layman's language, Mr. Speaker, how many bills do you anticipate that we should do today?
Well, Mr. Thompson, we've dispensed with 11 bills. I think something on the order of 50 would be helpful in terms of getting the file down to a manageable size.
So far we've done 11 and you want around 50 done
That
today.
is correct.
Thank you, Mr. Speaker.
The majority leader is recognized.
Thank you very much, Mr. Speaker. Under motions and resolutions.
Members, we are back under motions and resolutions.
If I may, I understand now the Joint Rule 61 waivers are at the desk. May we go to those items now?
We can, they are, we will. Clerk will read.
Resolved that Joint Rule 61A2 be suspended to permit the Committee on Health to meet, consider, and report Assembly Bill 1359 for further action, to permit that Joint Rule 61A9 be suspended to permit the Committee on Health to meet, consider, and report Senate Bills 1191, to permit the Committee on Local Government to meet, consider, and report Senate Bill 3, to permit the Committee on Transportation to meet, consider, and report Senate Bill 1146 for further action, to permit the Committee on Water, Parks, and Wildlife to meet, consider, and report Senate Bills 57, 530, and 1114, that Joint Rule 61A11 be suspended to permit the Committee on Water, Parks, and Wildlife to meet, consider, and report Senate Bills 57, 530, and 1114.
Debate or discussion? Clerk will open the roll. 54 votes, members. 54 votes to adopt the rules resolution. All members vote who desire to vote. 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 The clerk will close the roll and tally the vote. Ayes 72, no 0. The resolution is adopted. The majority leader is recognized.
Thank you, Mr. Speaker. I also request unanimous consent to waive the file notice requirement for the following committee actions, all of which passed unanimously this morning. Transportation to hear SB 1146, Burton on Monday, Information Technology to hear SB 678 Polanco upon adjournment today in the Rules Committee hearing room, and Elections to hear SCA 3 Burton upon adjournment today. These
Without objection, such will be the order.
Okay. In addition, Mr. Speaker, I request unanimous consent to rescind the July 6th action where the Assembly concurred in Senate amendments to AB 1222 Kuehl and return it to the Senate for further action. This is at the request of the author.
Without objection, that will be the order.
And also, Mr. Speaker, I request unanimous consent to allow Assemblymember Strawn Martin to take up her AB 1254 without reference to file. This has also been agreed to by leadership on the other side of the aisle.
Without objection, that will be the order.
Thank you.
Ms. Aroner, for what purpose do you seek recognition?
Yes, Mr. Speaker, under motions and resolutions, I'd like to remove item 138 from the second reading consent file
Clerk will note.
for the purposes of amendments.
Purpose of amendment.
And we've checked with both sides of the aisle. Thank you very much.
Clerk will note. Mr. Washington, for what purpose do you seek recognition?
Mr. Speaker, I'm looking for my file item. Yeah, can I come right back in a second?
Yes, you can. Ms. Davis, for what purpose do you seek recognition? Ms. Davis.
Yes, thank you, Mr. Speaker. I just want to announce that Consumer Protection Committee will meet on the call of the chair in room 447 following session.